All right, Eric, are you ready?
Yes, they may have to pull, I don't know if Mr.
He may
Gluck
not
is in
be
the
down
quorum
there
or if they
yet,
have to
sir.
pull him.
They're pulling them by where they are on the docket. They're not bringing everybody down like they did before. Is Robert Gluck in the courtroom yet? Deputies, could you all do me a favor, please? We have a lawyer up here. If you could bring Robert Gluck to the courtroom, please?
Robert, do you know which facility and what page, Judge?
He's at Maine.
Maine and page 24. Robert, Gluck.
They're gonna get him, Judge.
All right, counsel, we'll just have to wait till he comes down.
Understood.
If you
Thank
wait a
you.
minute, thank you.
Thanks, Tony.
Mr. Romero, you let me know when Mr. Gluck gets here, please.
I will, thank you.
All right, what do we want to do here? We have a mother on one case. I don't know whether that case is up. It is? Okay. Mr. Romero, are you there? This main jail?
Yes, sir.
All right, this first case is a domestic violence case. The mother is here,
We're ready to proceed on that case.
Ashley Mitchell.
Come on up, Ms. Mitchell. You're a main judge.
So this is charged as a misdemeanor, right? I guess Judge McHugh isn't doing these this week, right?
Well, actually, Your Honor, based on the false imprisonment charge, that it would be a felony.
Okay, so that's what the count draws as a felony. All right, good morning, ma'am. I have a note here that says your mother is in the courtroom. Are you Ashley Miller? Mitchell?
Also her fiance, who's
Okay,
the alleged,
Ashley Mitchell.
is here too.
Okay, all right, everybody hang on. Okay, ma'am, this morning you're charged with two cases, touching or striking a battery during a domestic violence incident or alleged domestic violence incident and false imprisonment. The second count is a felony, the first count is a misdemeanor. Counsel, have you been able to talk to her at all?
I'm sure Mr. Romero has, Judge.
Mr. Romero, anything you want to tell me about her situation?
Well, I'd like to say something first. I don't even know that there's probable cause to find a false imprisonment charge here. It looks as though, according to the probable cause affidavit, Ms. Mitchell allegedly grabbed Mr. Lau's hand against his will and restrained him by grabbing his hand. I don't know that that's a false imprisonment at all, Judge.
Well, it says, it didn't just say that, it says prevented him from leaving the residence.
And I would note, Your Honor, this is not only what the alleged victim told law enforcement, but also allegedly Ms. Mitchell advised that was her intent.
I still don't see it. He grabbed her hand, she grabbed his hand in an attempt to prevent him from leaving the residence. It's not like he was locked in a room or she was blocking the door. She grabbed his hand, which is probably how he got the scratch on his hand.
Well, now Ms. Aridi's arguing the severity of the offense, but as far as probable cause for the legal definition, the statements made by both the victim and defendant satisfy the legal elements, Your Honor.
I understand
Well,
your argument.
let me just say this, Judge. It's weak.
That I would not dispute, but the question is whether it's sufficient enough to be probable cause.
I don't. If you want to find probable cause, that's fine, but it's weak. And I'm going to be asking the court to release Ms. Mitchell on her own recognizance.
All right, well, let me give some more details here. I agree, it's not the strongest PC, but I believe it passes muster for the probable cause, the determination I need to make this morning. So I'll overrule your objection and find probable cause on both counts. Okay,
Judge, if I may.
Mr. Romero, go ahead, sir.
Judge, certainly for mitigation purposes, you can take into account the strength or weakness of a case, and I'd ask you to do that at this time. Besides that, Judge, my understanding, this is Mrs. Mitchell's first contact with the criminal justice system. She has a clean record. She's a registered voter. She's been here her whole entire life. As you see, she has strong family ties. Her mother's here. Her fiance's here. My understanding is that the fiance's not in fear, wants contact, is probably going to go to state attorney's office, fill out a waiver of prosecution. So the weaknesses of the case, it's very weak, Judge. Based on the fact that she has no priors, that she has strong ties, she's She's on maternity leave right now, taking care of her 10-month-old child, Judge. She's a school teacher. I'm going to be asking the court to consider a straight ROR. She will be coming back to court. She's not a flight risk. She's not a risk to the community.
And Judge, I've spoken with Mr.
Both
Lau
of y'all,
and.
Mr. Reedy, just 1 second, please. Give both of
Sure.
you raise your right hand. Swear affirm me testimony about to give me is truth, whole truth, not the truth. All right, let's start with the female. Your name, ma'am?
Marcia Furtado.
Spell your last name.
F as in Frank, E-U-R-T-A-D-O.
Okay, just so you know, that blue light means that everything in this courtroom is being recorded. And next to you, sir, your name?
Robert Lau,
Spell your last name.
L.U.
You're the alleged victim in the case?
Yes.
All right, Mr. Reedy. Wait a minute, how many lawyers do I have arguing this case, Mr. Reedy?
I'm sorry, Judge?
How many lawyers do I have arguing this case? What do you want to tell me, sir?
I want you to release her on her own recognizance, and I don't want you to issue a no contact order.
All right, your colleague made that argument. What do you want to tell me, ma'am?
My daughter, it's her first offense. She's a good girl. She has a baby. It was just a misunderstanding that got way blown into proportion. And I'm just asking you, as a mom, a leniency for my daughter. Because this is her first offense and it was not intended to be this big overall thing. And so I just ask for mercy for her.
All right, well,
I love her and I want her to come home to her
all right,
baby.
I understand that, ma'am. Sir, anything you want to tell me?
I had no intent of this. I just called her, and she was worried, so she didn't think this was going to escalate this
Right.
far. I have no fear of her. That was the only was when she grabbed my arm. That's it, and I wasn't against my own will on any of this.
All right, thank you, sir. Mr. Linder, anything you want to say on the case?
Your Honor, I can confirm she has no history. The state's recommendation will be a $1,000 bond on each count, no victim contact.
All right, in this case, because she has strong ties to the community, the victim is here, not pressing the matter. I will release her on her own recognizance with a no harmful contact, meaning, ma'am, you are going to be released. You can have contact with the alleged victim in the case. It's a no harmful contact situation. You need to mind yourself, both of you, while this case is pending.
Your Honor, if I may, if the court's inclination is to order no harmful contact, then I would just ask the court, frankly, to just allow contact. The reason being, there can be some confusion sometimes when there's a no harmful contact, because that isn't
So
necessarily.
just permit contact.
Yeah, because just so the court understands, that doesn't necessarily get entered in the system.
Okay,
A law enforcement officer encounters them, he may see no contact, and that could end up in an arrest.
all right, very good.
I agree with Mr. Linder. Also, harmful contact is against the law anyway, and would be a violation of her conditions of
I'll
bond.
follow
so-
Mr. Linder's recommendation there. You can't have contact, sir. Both of you need to behave yourself while this case is pending. See the division judge and see how the case comes out. Good luck to both of you. Have a good day.
Thank you, Judge.
So we'll just go down the dock.
Judge, the person that you told me to inform you when he arrives, he's here. He's on, Mr. Gluck.
All right, thank you, Mr. Romero. Mr. Gluck, you have a lawyer here in the courtroom.
Your private attorney's there present,
And,
okay?
Your Honor, if I could be heard before the court makes a finding,
Okay.
thank you.
All right, Mr. Gluck, I've read a probable cause here. You have a lawyer here in the courtroom. Counsel, again, your name is?
Morning, Judge Scott Kotler, Kotler, on behalf of Mr. Gluck.
All right, welcome, Mr. Cutler.
Thank you,
Okay,
Judge.
you're charged with 4 counts, sir. Burglary with an assault, touch or strike battery, and criminal mischief over $1,000. I've reviewed the probable cause affidavit and found probable cause on all 4 counts. The state attorney wants to be heard.
Yes, Your Honor, actually, on the first count, I know on your findings in the booking, it says burglary with assault or battery. I believe that was, there was a miscommunication, something happened where it was incorrectly put as a burg bat. I would direct the court's attention to the affidavit. If you look at the top charge, it was just charged as burglary after permission to remain is revoked. And it would appear, and I spoke with counsel, the factual allegations would support that.
Okay, so count 1 now is a burglary
Should just
without
be a
an assault.
burglary.
All right.
That's
And
correct, Judge.
We've agreed to bond and release conditions if acceptable to the court. Your Honor, that would be a $5,000 bond on count 1, and the standard bonds left in place on the remaining counts. No victim contact and no return to this listed business, which is Maurice's Jewelry Box.
Is that your agreement, counsel?
Yes, Judge, and I would just point out, if you look at the affidavit, you'll see that the battery, the alleged battery, happened outside of the store. So
Right.
that's why there really isn't a burglary with a battery. So this should be bondable. We have an agreement for 5,000 on that and a total of 7,500.
All right, I see no reason to not follow the agreement between council. When count one, the bond will be set at $5,000, count two, 1,000, count three, 1,000, and count four, $500. Those will be your bonds, sir. You'll have to post those bonds and get out a condition of your releases. You don't return to this business where this incident occurred, nor have any contact with the alleged victim in this case, who purports to be Robert Maurice Seton. Is that right, Mr. Dictator?
Maurice Seton, yes, thank you, Judge.
You understand, sir? Well, Mr. Romero, you got to turn the mic on. Thank you.
Yes, I do.
All right, sir. Good luck to you.
Judge, I have one quick request, and
Yes, sir.
that is, and I have his wife present, they have a pre-planned, non-refundable cruise set for Wednesday, the 17th of this month through the 30th. State has no objection to this court granting my request for permission to go on that cruise, that international cruise.
I have no objection.
Okay, right in order.
Will do.
Have a
Thank
good
you,
day.
Judge.
Thank you. All right, Mr. Romero. No other lawyers?
Yes, Judge.
I guess let's go down the docket.
Okay.
Sorry? Oh, I don't know about all your cases here, Mr. Shade. We got a whole bunch of people. I don't know who's,
Judge, I believe there's gonna be a good handful of them that are,
Already
medical
there?
resets.
Pull the case.
or what, medical resets?
Medical resets, right.
All right, Mr. Romero, let me see how many of these I can do real quickly of these MOs.
No problem, Judge.
Ventre, V-E-N-T-R-E.
Oh, Melinda Ventry, North Broward, Judge.
Judge, she's a medical reset from yesterday. I'm not sure if they have her again today.
She's at Paul Ryan Yard.
Sounds good.
Okay.
Judge, due to the number of charges that she has, the city of Hollywood would prefer that it just goes straight to the division.
All right, I'm having a little trouble finding all these cases in this stack. Oh, it's, no wonder, it's the second case, no wonder. Holy Christmas, look at this.
She's the winner of the day.
You are the winner of the day, ma'am, for sure, without looking at the rest of the docket. You are before us, ma'am, on, it appears to be 13 capiases. There's probable cause based on the finding by Judge Calra. 13 capiases mean you failed to appear in court at least 13 times. Are you at large, ma'am? You don't have a permanent address? Ma'am? No?
I think her mic is off.
No, it's
Now
on.
I do. Now I do.
Goodness gracious, she's got page after page. Trespass, 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 trespass. Open container. Trespass. All right, ma'am, from looks of what I'm seeing here, you're not being a very good citizen, and although these aren't the most serious offenses we see, when you fail to appear in court 13 times for these kind of charges, my hands are tied. You're going to have to see the division judge. Mr. Shape, maybe you can get this thing brought up fairly quickly in front of the division judge so it doesn't linger, or she said in jail maybe next week.
I think it does actually go to jail, to court next week, Judge.
Okay. There's probable cause on all 13 cases, ma'am. I'm going to set your bond at $1,000 on count one. You can make that bond, so be it. The rest of the bonds will be zero. You'll have to see the division judge next week. Good luck to you. Count one, 1,000. Yes, I am. Thank you. Let's see here. Next was Weimer. Weimer's on page 5. Next case up, Weimer. Ashley Weimer, is that you, ma'am?
Yes, sir.
Judge, the city of Fort Lauderdale would offer a time served offer.
What time?
Time served, correct.
Ma'am, you're in custody on a charge of a capias for failing to appear. She only has this one case, right? On petty theft. The city of Hollywood's offering to resolve this case by, does she have much of a record, Mr. Linden?
You're gonna I'd have to
you
check
didn't look.
her name, please.
Weimer,
Ashley Wyman. Judge, I can say I've never had to deal with her before.
okay.
This-
All right, based on that, I will withhold adjudication and sentence you to time served, ma'am, if that's what you wish to do.
Yes, sir.
All right, ma'am, you'll You'll be released, assuming you're not being held on any other charges. That'll be the disposition in your case. Good luck to you.
Thank you very much.
Yes, ma'am. I didn't put anything in those cases, Madam Clerk, as far as, today's what, the 12th?
Yes, sir.
That's your order? All right, thank you, counsel. The next case you had is, so this is Weimer. Is that Bowman? No, can't read your writing there, Mr. Shade.
What page do you have on that, Judge? Oh,
B.I.
Biswas.
Biswas, okay.
Judge, she also has a state case, so that, we just asked that this go to the division. Harry Biswas, member, on page 12. Biswas.
Biswas. I got it.
Biswas,
B-I-S-W-A-S.
main jail.
So she's charged with a VOP on a domestic. Okay, main jail. Mr. Romero, do you have Harry Biswas there, please?
We have Mr. Romero.
Deputy? Anyone. Sleeping on a park bench, okay. And the other one is,
Judge, I apologize. Who are you looking for?
Biswas, B-I-S-W-A-S. You may not be
what
down.
page?
You may not be down yet.
I'm sorry. 12.
Page 12.
Mr. Biswas, are you here?
All right, we'll bring him down.
Biswas, oh, he is here. Mr. Biswas is here.
Thank
Come on
you.
up, Mr. Biswas. He's approaching, Judge.
All right, good morning, Mr. Biswas. You're charged with two cases. Two cases today. Count one is a violation of a domestic violence injunction, and the second case is a capias on a municipal ordinance sleeping on a park bench. Number one is a no bondable offense. You're going to have to see the division judge probably on Monday on the violation of the domestic violence.
He's
It's
entitled to a
bondable,
bond,
Your Honor.
Judge.
He is entitled to bond on that one?
Yes, Your
Okay.
Honor.
Who is he seeing on those? The Judge Inspector?
No, this would go before Judge McHugh.
Oh, McHugh, okay, so it's a misdemeanor.
Yes, sir.
All right. Do you have a permanent address, sir?
Judge, at this time, he's homeless, Judge. My understanding is the injunction is referenced to his mother that he can no longer have any contact. I did tell him he can't have any contact. Unfortunately, he doesn't have his place to stay. The only good news right now going for him, Judge, he just got a job this week at the Brews Room as a server, making about $5 plus tip. But he advised me, Judge, there's no one that's going to help post his monetary bond, so he's financially indigent.
What's his record, please?
Your Honor, he has no history. That being said, I reviewed the petition that his mother, the sworn petition, his mother prepared prior to the permanent injunction being granted. This is not the first time he's gone to this property when he wasn't supposed to. The mother lives in this is a HUD development building. Management has advised him previously numerous times he cannot go back to this property. He continues to return. She describes that his behavior has gotten increasingly hostile, aggressive, and physical, Your Honor. And she voiced great concern to, I believe, Judge Moon, who issued the permanent injunction. I would be requesting a $2,500 bond and no victim contact.
All right, sir. If what's alleged to be true in the petition, that you have returned here on more than one occasion while under an injunction, we take these domestic violence injunctions very seriously here at the courthouse. There's no gray line, really, because you know you're not supposed to go within 500 feet. And so it's not one of those things where you innocently did or didn't do whatever you're charged with doing. On count one, I'll set the bond at $1,500. Count two, the bond will be $50. You'll have to post those bonds and see the judge, sir, and you are under no circumstances to return to this address where your mother is located and you are under the domestic violence no contact order. Do you understand?
Yes, Your Honor.
All right, Mr. Biswas, good luck to you, sir. Next is Tiffany Jean Hackett. Oh, I'm sorry, we're still doing your cases. L-E-A-C-H, page 15, L-E-A-C-H. If he's there, Mr. Romero, I don't know if he's there. Leach?
Wesley Leach, come on up, please. Wesley Leach? Wesley, come on up, sir. He's approaching, Judge.
Thank you, Counsel.
Judge, the city of Pompano is offering him time served.
Okay, if I can find his paperwork, I will offer him that.
He's also on trial for it.
He's on pretrial for a petty theft?
This is a violation of that pretrial? Oh. Judge, we prefer that it go to the division.
Yeah. All right, Mr. Leach? I still can't find his paperwork. Anybody know what page he's on?
15.
I still can't find it. Be way back? Maybe that's why.
Warrant signed. June 20th, no, well, it's an Odyssey.
Let me turn that noise off for a minute. Just having a hard time finding his paperwork, Mr. Shea.
If you want to skip over it, just knowing that it's going to probably go to the division. fine with me.
Yeah, I'll just find PC. All right, Mr. Leach,
Yes.
how old are you, sir?
I'm 23.
26?
Two.
23.
Do you have permanent housing, sir?
So is that?
I said, do you have a permanent place to live?
No, I do not.
Pass it.
Sir, I need you to, I'm gonna,
Judge?
yes.
Just so the court's aware, apparently he was on pretrial on a separate petty theft that Judge Diaz signed a warrant on June 28th for violation of pretrial because he never reported once he was released from custody.
Never reported the pretrial.
Just never reported a pretrial. I imagine pretrial is gonna bring it to BSO Warrant's attention to have that warrant served on him, but that has a $500 bond on that. Yeah, that's separate and apart from.
Well, I'm more concerned that he's 22 years old and is living on the street. That's what I'm more concerned about this morning.
Understood.
His judge is Diaz.
Yes.
I'm gonna have his case, I'm gonna send his case to Judge Diaz, but I'm gonna ask him to send it over to community court, see if we can find him,
Judge, I'm not sure if he's eligible. It's out of the Pompano Beach.
it's what?
It's not eligible due to the fact it's out of Pompano Beach.
Oh, it's in Pompano Beach,
Correct.
but he's now homeless in downtown Fort Lauderdale, isn't
Well, this arrest was from Pompano.
he? I know, but as soon as they put him out the door, he's gonna be in the
He'll
city
be
of Fort
homeless in Fort
Lauderdale.
Lauderdale until,
See, I know how to get around that, Mr. Shade. Okay, here it is. I got your paperwork, Wesley. Mr. Leach, how long have you been without permanent housing, sir?
About 2 years.
Sir, I need you to come to community court and see if we can find you employment and a place to live. You shouldn't be on the street for 2 years at age 22. You willing to do that?
Yes.
Okay, on this case that you're charged with, I'm finding probable cause. It's a minor offense, sir. You're charged with a municipal ordinance violation out of Pompano. And the only thing you were doing, it looks like, is panhandling between traffic. I'm gonna send your case to Judge Diaz, and I'm gonna ask him to send you to community court on Wednesday of next week. I'll find probable cause in this case. You're gonna have to stay in custody until Wednesday. I'm revoking his pretrial release. I'm revoking your pretrial release because you got a new offense while you were on pretrial release and you didn't report. So, sir, I'm gonna hold you in custody. I'm gonna write your name and case number down. I'm gonna talk to Judge Diaz on Monday. And I'm gonna ask him to send your case over to me in community court. You understand?
No, you do not.
You do not understand? Do you want to be employed and do you want to be off the street, sir?
Yes.
Okay, then you need to come to community court where we can find out what your problem is and see if we can get you housed. So I'm gonna let Judge Diaz see you on Monday and ask him to send you to community court on Wednesday morning at 9 o'clock in the City of Fort Lauderdale County Commission Chambers, City Commission Chambers. And I'm gonna see if I can find you a job and a place to live, sir, okay? For right now, you'll be held on these two charges until you see Judge Diaz on, I'll try to get him to bring you up Monday afternoon.
Monday afternoon?
Yes, sir. All right?
All right.
Good luck to you, sir.
Thank you.
Let me write that down. Joe, give that to Joe, will you? I'm gonna forget that. Can you hang on to that for me? Thank you. Green, page 16, should have been right after him.
Page 16.
Lamont Green, not John.
Green. Mr. Green, come on up, sir.
Lamont Green. There's two.
Mr. Lamont, Tyro Green. He's approaching.
Good morning, Your Honor.
Good morning, Mr. Green. I'm looking for your paperwork again. I have a John Green, that's not the right one, right?
No, it should be about 7 after that.
7 after that, thank you. Lamont Green, I have it. Sir, you're charged with the municipal ordinance violation. The city says,
It's a type of it's an open container.
all right, charged with having an open container, sir.
Open container. I don't even want.
All right, I'm just reading what they say, sir. I wasn't there. What's the city's proposal?
Time served, Judge.
All right, sir, they're offering you time served on this charge of open container. I'll adjudicate you on the municipal ordinance violation if that's what you wish to do, meaning I'm finding you guilty. But I will release you on time served. You wish to do that?
Yes, sir.
All right, sir, stay out of trouble. Don't get arrested again, all right?
Okay.
Good luck to you, sir.
Uh-huh.
Next is
Next case should be the very next one after Mr. Green.
Bellany.
And then, Judge, if you want to keep this next one after that.
Anthony Bellamy. Anthony Bellamy. Thank you very much.
Same thing, Judge. The City of Fort Lauderdale office time served on this gentleman.
All right, sir, you also have an open container violation and a whole bunch of aliases. I'll adjudicate you on this charge if that's what you wish to do and sentence you to time served. Do you wish to do that?
Yes, sir.
All right, sir, don't get arrested again, all right?
Yes, sir.
You know how many pages of aliases he has? You see this? How many different names have you used, sir? You got like 50 names here. All right, I'm just commenting, sir. Good luck to you. Have a good day.
Judge, the next gentleman, Cedric Greer, has been in medical reset for about 3 to 4 weeks now. He was Baker acted on the day that he was taken in. Judge, if we could ROR him, I think they've already found probable cause. I'm working at the City of Hollywood to have that case no crossed so they can.
He's got a whole bunch of resets. I'll definitely ROR him.
Thank you.
He shouldn't be in the jail.
He's actually in a medical facility.
All right, I'll ROR him, Mr. Clerk, please, and everybody in court. I think that's all I had on you.
Excellent. Thank you, Judge. Good
Thank
seeing
you, Mr. Shade. Have a good day, sir. Any other lawyers? Any other family members? Which case are you guys all huddled back there on? Any of them that have any interest looking? All right. We may not have anything interesting.
That's the press, Judge.
I see them back there. They're always fishing around here for a story. I know what they're doing. Okay, Mr. Romero, we'll go back to the regular docket. Tiffany Hackett, please.
No.
Thank you. Petty theft, second offense. Why is this petty theft? It says there's 6 checks stolen from her checkbook. Oh, she only 78 to 840. That would be more than petty theft, wouldn't it, Mr. State Attorney?
Your Honor.
Oh, it's second degree larceny. Okay.
Yeah, and I think it's
Says-
based on the actual value of the checks, not the amounts that was written on the checks. Either way, at this
In
point.
any event, she has no bond holds on other counts, Judge. I'd
She
ask you to
does?
just leave the $100 bond in place on this charge.
Okay. She's got other cases going.
Violation
This is
of
count
probation
11.
holds, yes, Judge.
All right, ma'am, this is count 11 of a series, it looks like. So I'll leave the bond in place as per the request of the public defender. Find probable cause, the bond will be set at $100. You'll have to resolve all of these cases before you can get out of custody. Good luck to you, ma'am. Have a good day.
Thank you.
We're all so happy today. What's Julie Stadler?
She's in she's in Ryan, Judge, Paul Ryan.
Good morning, Ms. Stabler. You're charged with
morning.
a series of cases this morning, adding on to probably other cases. Counts 12, 13, 14, 15, 16, 17, and 18. It looks like there's also a VOP here. Give me just 1 second, ma'am. The Ninja Blender. Okay, the grand theft appears to be the Ninja Blender, right? That's what I read.
It's multiple items, Your Honor. Beauty products,
Oh, there's another PC here.
gift card, it was $507 worth of
Yeah.
merchandise.
All right, ma'am, in counts 12 through 18, I find probable cause to believe you may have committed the offense to which you're charged. On counts 15, 16, 17, and 18, those are all allegations that you violated your probation, which means you'll have no bond, but you will probably see your judge on Monday on those cases, depending on how those other cases are situated. So good luck to you, ma'am.
Yeah, I'd just ask the court to leave the bonds in
I
place
did.
on 12, 13, and 14.
I left them exactly where they are. Count 1, the bond's 1,000. Count 2, the bond's 100. Count 3, the bond's 100, and the rest are no bond holds. Okay? Good luck, ma'am.
Thank you.
Yes, ma'am, thank you. How about Amelia Martinez?
All right.
All right. You speak English, ma'am?
Yes, I do.
Okay, you're here on an immigration hold from the Department of Homeland Security. So this immigration detainer means that you will be held in the county jail until the federal government does something with your case. So find probable cause to hold you based on the immigration hold, and you'll have to see what the federal government does with your case, ma'am. Good luck to you.
Thank you.
Yes, ma'am, thank you. Everybody's so nice this morning. Malika Gaskin? Malika?
Judge, I've been advised, I believe she's in regular court.
Oh, she's in the courtroom with the
Garcia
judge?
Wood.
Just ask that this be reset for tomorrow, Your Honor.
All right, I'll reset this tomorrow based on the fact that she's in the court. Thank you, Mr. Romero. Raquel Showers?
No problem.
Good morning. You're Raquel Showers?
Yes.
Ma'am, you're charged with 7 cases this morning. Possessing a forged driver's license, 3 capiases, and a number of out-of-county holds. Give me just 1 second, ma'am.
Okay.
So you have a capias on a grand theft charge, therefore probable cause was established by the prior judge. You have another capias on a grand theft charge with the same situation, and you have several out-of-county holds. Therefore, there's probable cause to believe you may have committed all of these offenses. On the out-of-county holds, you'll have to see whether these counties are going to come and get you. Right now, there's probable cause on all 7 of these cases. You'll be held $1,000 bond on the forged driver's license case. The capiases are no bond. Excuse me, wait a minute. Is she entitled to a bond on those capiases?
No, Your Honor.
Oh, they determined no bond. I can change that, but I won't. And on the other 3 out-of-county holds, you'll also be held on those. You're not going to get out of custody for a little while till you get these cases resolved, ma'am, okay?
Okay.
Good luck to you.
Okay.
Stephanie Burton?
No problem.
Thank you. All right, you're Stephanie Burton?
Yes, Your Honor.
Ms. Burton, you're charged this morning with possession of cocaine and possession of drug paraphernalia. Give me just 1 second. Okay, the cocaine field tested positive, therefore there's probable cause How long you lived in Broward County, ma'am?
48 years.
28 years?
48.
48 years. Do you work?
No, Your Honor.
No? Who do you live,
No.
who do you live with?
I live with a friend.
Do you have resources to pay a bond to get out of custody, ma'am?
No.
Do you have any savings or checking account money?
Nope.
She got a record.
Yes, Your Honor, she has a drug history, but it is dated as far as
Yeah.
Broward.
I think the last time she was in trouble, from what she told me, was like 2010. She's not going to be able to post a monetary bond, Judge, but she does indicate to me that she, as she's told the court, she does have a place to stay. I'd ask the court to consider releasing her on her own recognizance.
All right, ma'am, because of your 48-year ties to the county, in fact, you don't have much resources, I don't see you're going very far. I am going to release you on your own recognizance with the caveat that while you're on your own recognizance, waiting to resolve this case that's pending, you're not to get arrested again or get in any more trouble. Do you understand?
Yes, Your Honor.
I'll release you on your own recognizance, but you're going to have to come back and answer to these charges. It is your responsibility to find out when your court date is. It's not the public defender's or your grandmother's or anybody else's. It's solely yours. If you do not come back to court, a warrant for your arrest will be issued, okay?
Yes, Your Honor.
All right, you'll be released, assuming you don't have any other holds, ma'am. Good luck.
Good luck.
Thank you.
Take care.
Raina Melissa Mims?
Judge, she bonded?
She bonded, thank you. I do find probable cause, and she bonded. Next is Janae Jarrell Moody.
She's in Paul Ryan, Judge.
All right, ma'am. Listen carefully to me. Don't say anything while we're here, please. I'm going to appoint the Office of the Public Defender to represent you for at least this hearing.
Your
We
Honor.
do represent her, actually, Judge. Her attorney is Maria Della Guardia.
Thank you. Yes, sir.
Your Honor, that's what I was going to advise the court.
All right, ma'am. You're charged with murder in the second degree with a deadly weapon. The murder charge results from a capias from Judge Cholera, who found probable cause. Therefore, there's probable cause in your case.
Your Honor,
Yes.
actually, this hasn't been brought before Judge Collier yet. If I may provide the court with the procedural history so far,
Go ahead.
Thank
Why
you.
am I looking at a capias with this charge?
because it was a change of charge, Your Honor. It was down, Your Honor, when Miss Jarrell Moody was arrested, she was charged with premeditated first-degree murder. She appeared before Judge Florence Barner Taylor on June 24th at first appearance. Judge Barner Taylor found proof evident of presumption grade, ordered her to be held no bond. Your Honor, we have filed the charge as murder in the second degree, Your Honor, and I would argue, I'd ask the court to adopt the findings of Judge Barner Taylor, that order that Ms. Jarrell Moody be held no bond. Certainly, if there's proof evident presumption great for premeditated murder, then it would follow there is proof evident presumption great for murder of depraved mind without premeditation.
All right, I will make such a finding based on your representations. You'll be held without bond, ma'am. You'll have to see the division judge. There, you can certainly apply for a bond if you wish. All right? Good luck to you.
Thank you.
Yes, ma'am, good luck.
Judge, I think you might have skipped Miss Kelly Chapman.
I did?
She
You see
would be
anything
right
over there with
before Miss Jarrell Moody.
Oh, no wonder. I had all of them stuck together here. All right, thank you, Mr. Reedy.
What do you
So that's main jail. Kelly, Mark Broward again. Kelly Chapman.
Yes. Yes.
Kelly, you're charged with possession of cocaine and drug paraphernalia. How long you lived in Broward County, ma'am?
About a month and a half.
And where did you live prior to that?
I was in Ohio.
Are you working?
No.
Field test positive on the cocaine. There's probable cause to believe you may have committed both the offenses to which you're charged. Ma'am, you've only been here 1 month. You have the resources to pay a bond?
I'm working on it, but possibly not.
All right, ma'am, you don't have really any ties that you've given me to Broward County. You said you last lived in Ohio and you've only lived here a month. I have to be assured that you're going to come back to court and answer for these charges. Does she have any record that you can see?
I'm pulling that right
Thank
now,
you.
Judge.
You know anybody else who lives here in Broward County, ma'am?
I do know a few people.
Thanks.
Your Honor, from what I can tell, it looks like there are pending charges out of Ohio. Disorderly conduct, drug paraphernalia, possessing drug abuse instruments. That was a February 7th, 2019 offense. Your Honor, just based on my experience, and I don't know if the court wants to inquire, I suspect what we're dealing with here is a situation where Ms. Chapman may have come down to Florida from Ohio to seek drug treatment. And what we see very often is when people in these situations, they leave the drug treatment, they're out on the streets of South Florida, Broward, and then get into issues with drug abuse.
All right, well, I don't know about all that, but what I do
No.
know is, based on the fact that you were arrested in Ohio just recently this year, and you don't have strong ties to the community, I'm leaving your bond at $1,000 in this case, ma'am. You'll have to post that bond, but you also will have to come back to Florida and fight these charges if you so choose. Otherwise, you don't come back, you'll be in the same situation. The state will issue a capias for your arrest, and if you ever show up in Florida, you'll be held no bond on these cases, all right?
All right.
Good luck to you, ma'am.
Thank you.
All right, I'll call your dad for you, Kelly.
Thank you.
Katrina Nicole Veal.
She's approaching Judge here at Maine. Come on up now.
Good morning, ma'am. You have a out of county hold for a charge of voyeurism,
It's out of state, Your Honor.
out of state hold. Therefore, you're going to be held pending whether that state will extradite you based on this charge. So you're held no bond on this charge right now. You're going to have to, she goes through extradition?
Yes, she will go before Judge Malika for an
You're going to go
extradition.
through Judge Malika's extradition probably on Tuesday and determine whether you're going to go back to the state where these charges are pending, okay? Yes, ma'am?
1 second. That's you.
Good luck.
He's got to go to judge.
You understand, ma'am?
Hello.
Yes.
Okay, all right, good luck to you, ma'am. You'll be seen probably on Tuesday.
Judge, I've been advised if we can call gentleman out of turn. Mr. Fonseca, the deputy, just advises he's, has to go to morning court.
Thank you.
So they want to try and do him.
Your Honor, he wasn't supposed to be
Mr.
brought back.
Fonseca?
Is that the DUI manslaughter case?
Hold on, I'm trying to find out who he is. Right?
Hang on, have Mr. Romero communicate with,
He's on page 19.
Page 19, Judge. He
so he's
is
not supposed to be on?
immigration hold.
No, I guess it's just the immigration hold, Your Honor.
Oh, okay.
Mr. Fonseca, come on up.
I didn't.
I'm still looking for his paperwork, Mr. Romero, if you give me 1 minute.
No problem, sir.
All right, I can't find his paperwork at all. All right, I have it. Yeah, you're right. All right, Mr. Fonseca, good morning, sir. You're here this morning as a result of an immigration hold filed by the Department of Homeland Security. As a result of that hold, you'll be held in the county jail till they decide what to do with you on that immigration hold, and you may have other cases already pending in the court. So right now, you'll be held on this immigration hold, sir.
Nothing else. Your Honor,
Thank you, sir. Good luck.
Your Honor, just want to advise you, the Creole interpreter is present in court.
Yes,
Creole?
there is someone in the main jail who requires the services of the Creole
Yes,
interpreter.
that gentleman is on page 12 of the docket.
It's actually, I think, your next, I
Mr.
think it's your next case.
It is.
Shaitlin?
It's funny how
All
that
right,
works out.
that is the next case.
Mr. Shaitlin? Shaitlin Rusby? Come on up, sir.
Judge Tuller,
Yes.
on count 2, it says no bond, but the bond is $1,000. Can you just take out the ND?
Take out the NV, yeah, it says 1,000 on the sheet, okay, yep. All right, Madam Clerk, please raise your right hand, you swear to affirm you will truthfully and accurately translate the Creole language into English during these proceedings?
I do. Vivian St-Ange, ST.ONGE.
All right, Mr. Chatelain, you're charged with
Monsieur Châtelain,
2 cases this morning,
yo accusé avec 2 crimes matin,
a domestic battery
yon violence domestique,
and a capias.
avec yon mandat pour arrêter ou.
The capias is battery.
Et pour mandat, c'est côté bâton moun.
Did you used to live at Southwest 2nd Street in Pompano, sir?
Ou te habite dans Southwest 2e Street dans Pompano?
Oui, yes.
Yes.
That's where the paperwork went.
Your Honor,
Yes, sir.
this is actually capias that Judge McHugh issued on an unserved summons.
Okay. She's already established a bond on it.
Yes.
And on this new case,
Et dans nouveau accusation,
I find probable cause to believe you may have committed the domestic battery.
j'ai une cause probable côté fait un crime de violence domestique.
All right, there's a bit of a dispute about what happened. Okay, there is a dispute about what happened. All right, counsel, anything you want to say?
Well, Your Honor, there's a dispute in that he denies what occurred.
Juge, oui, gen yon diskusyon ke li pa aksepte ke sa k te pase a, sa yo di k te pase a.
But apparently there's a security guard at the location who witnessed the incident
Men gen yon gad sekurite ki te la kom temwen.
and asked him to let the victim go.
Ki te mandel pou lage viktim nan.
The defendant said that he grabbed her, and then the police officer puts in the adjectives, willfully and maliciously refused to let her go.
Akuse a di ke li te lagel, men polis la make ke li pat vle lagel.
Whatever it is,
Li
there
refize
is
lagel.
probable cause. Sir, are you working?
Wap travay, monsieur?
Yes.
Where?
Ki kote wap travay?
Landscaping.
Landscaping.
Landscaping? How long you lived in Broward County, sir?
Pou
Or
konbien
South
tan?
Florida?
Pou konbien tan depi wap viv nan Broward?
Décembre a fait 3 ans.
In December, I'll be 3 years.
Anything you want to tell me, Mr. Romero? Or you couldn't
Judge,
speak to him, you
unfortunately, I
didn't have the
wasn't able to
interpreter.
communicate
Right.
with him, and all I
Juge
got
domaj
from
nou
him
pat
was
ka pale ansama
escaping.
veli.
What I wanted to ask him, is there anyone that can afford to post his monetary bond?
Sam Kamandel, eske gen moun ki ka paye l'ajan pou kosyon ou pou lage ou?
Mba gen numéro téléphone moun yo, numéro téléphone madame moun te gen. Mba chanje nan tèt mwen.
I don't have any phone number on top of my head.
Okay,
Your Honor.
do you have your phone in the jail, sir?
Ou gen telefon nou nan prison?
Non, téléphone moun nan moun te ba moun ki ta la ve nan police station nan, bon moun nan fè mè téléphone nan mwen mba jen sou li.
I gave it to someone who went with me to the police station, and they turned off my phone. I tried to call my phone, and it's not picking up.
Yes.
Your Honor, the state is going to be requesting a $4,000 bond on count one.
L'État mande pou $4,000 kom kosyon.
And the basis of that on this PC is what?
Pou base sou ki sa?
It's a totality of the circumstances, Your Honor.
Se totalite circonstans lan juj.
The alleged victim of count one is the same as the alleged victim as count two.
Victime nan premier krim nan, se menm victime nan deuxième krim nan.
Our office has had contact with her, and she is in fear of Mr. Chatelain.
Office nou an te kontakte li krent akuse a. Li pe akuse a.
The allegations of count two, which occurred March 14th of this year,
Akuzasyon 1 ki te pase 14 mars,
So Mr. Chatelain spit in the victim's face and punched her multiple times in the head and
Dit
face.
dit que Monsieur Châtelain te craché dans figi victime nan et bal coup de poing plusieurs fois dans visage li.
The victim's documented injuries were a golf ball-sized contusion,
Li te gen yon gros boule qui gros serra yon boule golf
to the left side of her face next to her eye.
nan visage li à gauche tout près yeux li.
All right, thank you, Mr. Linder.
Okay.
All right, based on what I've been told by the state attorney here, and based on the fact that the capias
Basé sur ça, l'État fin dim là et basé sur mandat d'arrestation
for the first offense was just entered in June,
pour première accusation qui t'est entrée dans mois de juin,
I agree with the state attorney.
d'accord avec l'État.
In count one, I'll set the bond at $2,500.
M'a mette pour première accusation $2,500
Count two, the capias is $1,000.
et pour deuxième nan amende là c'est $1,000.
When you can see Judge McHugh,
Lè que ouais en fait juge McHugh
you can make application if you can show cause
ou ka fait application sous ka montrer cause
to reduce those bonds.
pour réduire caution.
Sir, listen carefully to me.
Monsieur, écoutez-moi avec prudence.
Under no circumstances
Pas de aucune circonstance qui est capable de gagner
are you to have any contact with Jessica,
pour gagner aucun contact ensemble avec Jessica
who has the last name as you.
qui a même titre signature avec vous.
You can't call her.
Ou pas qu'à relé dans
You can't go
téléphone.
near her.
Ou pas qu'à approcher.
You can't email
Ou
her.
pas qu'à voir un email
You
bali.
can't have anyone on your behalf do that.
Ou pas qu'à demander pièce moun pour contacter le pour
This recording here is
gagner un enregistrement
going to be preserved forever,
qu'a prêté là pour tout
and
le
you will
temps.
have been warned by a circuit court judge
Et c'est un juge qui avertit ou
to stay away from her.
pour être loin de lui.
Do you understand?
Est-ce qu'on comprend?
Yes.
All right, sir. Anything else, Mr. Linder?
Just ask that the no contact order apply to both cases.
It'll apply in both cases. No
Oui.
contact order.
L'ordre que me passe pour pas de contact là, c'est pour tous les deux accusations. Yo.
Good luck to you, sir. Stay out of
Bonne
trouble.
chance, monsieur. Restez loin de problème.
Carlos Lugo?
Mr. Lugo is approaching judge. He's here, man. Come on up, Mr. Lugo.
Can you check his record, please? Mr. Lugo, you're also charged with battery during a domestic violence. Give me 1 second, sir. Don't say anything. All right, based on the probable cause affidavit, there's probable cause to believe you may have committed the offense of domestic battery, sir. You working, sir?
Yes.
And where do you work?
Atlantic Baptist Church,
And how long you been in South Florida?
39 years.
Do you have any kind of record?
No, Your Honor, the state would be requesting $1,000 bond, no victim contact.
You have resources to post a bond, sir?
Judge, he does. He has a debit card. He can get $500. I was going to ask the court for a straight ROR, if not in the alternative, for a $500 bond, and if I can get into the reasons as to why. As you can see,
I'm
this
going,
is a mis-
I'm going to agree with you, Mr. Romero. The bond will be $500. Sir, listen to me. You're not to have any contact with this lady who appears to be your ex-wife. You're not to go over to that house. Stay away from her until this case gets resolved. If you have issues relating to the divorce settlement, you need to go see the judge who handled your divorce. Don't try to do this yourself. So right now, you stay away from ELEIDA. Don't go near her. Don't go near this house until this gets resolved. Do you understand, Mr. Lugo?
Yes.
All right, the bond will be $500, and with those conditions. Good luck to you, sir. Oh, sorry, yeah. Good morning, sir. You a lawyer?
Spanish interpreter.
Oh, Spanish interpreter.
Judge,
Okay,
we're gonna have to put all the Spanish interpreters on recall. I wasn't advised, and they're in back, Judge.
all right, so we're gonna take a break in a few minutes, and we'll maybe come back in about 30 minutes. Would you do that?
I'll communicate with my officer.
Okay. You work for the
But
court?
we're ready to
You work for
proceed
us,
on
right?
all the other gentlemen, Judge.
Okay. We'll keep going. Excuse me. Darwin Perry.
Mr. Perry, come on up, please. Darwin Perry?
All right, good morning, Mr. Perry. You're charged with touch or strike during a domestic battery. Give me 1 second to see what happened. All right, sir. Based on a reading of the police report, there's probable cause to believe you may have committed the offense to which you're charged. Are you working, sir?
Yes.
Where do you work?
Demolition. We hired on the Edgewaters in Boca Raton now.
How long you lived in South Florida?
My whole life, 32 years.
Do you have any kind of record, Mr. State Attorney?
Yes, Your Honor. 2012 burglary of a dwelling and attempted burglary of a conveyance. State would be requesting a $2,500 bond, no victim contact, noting the level of violence that he punched the victim several times in the face, and noting the injuries that were documented.
Judge, I was gonna ask for the court to consider $1,000 bond on this misdemeanor offense. As you heard, he's been working with that company for 4 years, the demolition company. He has his mother and sister. He's gonna be living apart from the alleged victim. His mother works at a local store, and her sister is a security guard. So I believe if the court were inclined to set a monetary bond around $1,000 on the misdemeanor offense, his family can afford to post his bonds.
Yeah, set the bond in this case at $1,500. Sir, listen carefully to me. This is a serious allegation in this police report I'm reading, especially you allegedly striking this young lady. You're not to have any contact with Ashley Octavia Mack. That means you can't go near her, you can't call her, you can't have your friends call her. You have to stay completely away from her. That is a condition of your release. Do you understand me? Sir? We didn't get it. Very good. All right, your bond will be $1,500, sir, with a no contact with that victim. Good luck to you. Next is Alexander Sims.
Mr. Sims, come on up, please.
Good morning, sir. You're charged with 4 cases: grand theft auto, touch or striking during a domestic violence, violation of a domestic violence injunction, and obstruction, excuse me. What is that? Stealing the phone? Obstruction
Count 4 was, Your Honor.
to deprive of the ability to communicate. Is that like taking their phone?
It was preventing her from calling 911.
Thank you. All right, give me 1 second, sir. Let me check the paperwork. All right, these are pretty serious allegations, sir. There's probable cause to believe you may have committed all 4 of the allegations that are pled here. How long you lived in South Florida, sir?
23 years.
All right, I'll leave the grand theft auto bond where it is at $1,000. on the striking with a closed
Your
fist.
Honor?
Yes,
If I could provide some additional information to the court?
yes.
Your Honor, I think the court should be aware that Mr. Sims just pled and was adjudicated guilty last month, June 20th, before Judge McHugh, for violating the very same injunction against this woman. He also, in 2018, was convicted of resisting without violence. There was a charge of felony battery, great bodily harm against the same alleged victim that was dropped. Also in 2018, he was arrested for aggravated battery against a pregnant victim in violation of domestic violence injunction against the same alleged victim. Those charges were dropped. 2013, he was convicted of strong arm robbery, violated probation, was sentenced to 43 months state prison. Your Honor, I have a great concern not only for the victim's safety, but I also have a concern that Mr. Sims will not follow any no contact order that Your Honor imposes.
And Judge, if I may, as you heard, basically they were dropped. My understanding in speaking with Mr. Sims, he will be abiding by the court's order as far as no contact. He will be living separate and apart. He has family that reside locally. Now he is, as you heard, he's been here for basically his whole life. He's 23 years old. He's self-employed. He basically does roofing. He gets paid about, right now, the season's low, he's making about $200 a week, so not that much financial resources for him. Now, he does have family that live here. He's going to be reaching out specifically to his sister. His sister is a caretaker. He believes using the services of a bondsman, if the court were inclined to set a $1,000 bond on count 2 on the misdemeanor offense, on count 3 a $2,000 bond, and on count 4 a $500 bond. If my math is correct, that would be a total of $4,500. That's something that maybe his family can afford using the services of a bond.
And Your Honor, the state would be requesting a $5,000 bond on 2, a $20,000 bond on 3, $1,500 bond on 4, no victim contact, pretrial release of the GPS monitor, just noting also noting the physical injuries that the victim suffered that were documented.
All right, I appreciate your passion on his behalf, Mr. Romero, but his deeds seem to be stronger than his words. He's been under this domestic violence injunction, just pled to violating it last month, and apparently is violated again. He said that she got in touch with the victim here, took her car, punched her in the face. I think he poses a public safety risk to certainly the victim and the community at large based on his conduct, and therefore I have to set the bonds accordingly. On count 2, the bond will be set at $3,000. Count 4, the bond will also be set at $3,000. And on the obstruction, the bond will be set at $1,000. First count is $1,000. I'll leave it as it is, 3, 4, 5, 6. His total bonds will be $7,000. Listen carefully to me, Mr. Sims. This blue light's recording everything I'm telling you and can be used in a subsequent proceeding potentially against you. I can't emphasize with the strength of my office how strongly I'm telling you, you cannot have any contact with Alexandria. Is it Imtondai? Is that what it is, Mr. Public?
Yes, Detondo.
Detondo, the alleged victim in this case and the victim of the other cases that you've been involved with. You have to stay away from this lady. Do you understand?
That naming, right?
Do you understand what the judge just told you?
Yeah, I heard you.
Okay.
Okay, I didn't know if you heard me. I want to make sure you understand that you're to stay away from this young lady. Do you understand that?
Yes.
All right. Based on that, those will be your bonds, sir. Stay away from her. Good luck to you. Have a
Your
good
Honor,
day.
based on the nature of the offense as far as the state's request for a GPS monitor,
I'll put a GPS on him. Level 2. Thank you, Mr. Linder. And a level 2 GPS, Mr. Romero. Thank you. Charles Tanner?
Mr. Tanner, come on up.
I'm sorry, sir. I gotta sign this. Mr. Tanner, good morning, sir. You're charged with also some serious cases, so listen carefully to me. I'll appoint the public defender to represent you for this hearing and other purposes. You're charged with domestic battery, strangulation, and a violation of community control. The second is a no bondable offense. Let me look at what they say you did. All right, sir. There's probable cause to believe you may have committed the offense to which you're charged. Let me see what your record is.
Your Honor, in addition to the case he's on probation for before Judge Garcia Wood for grand theft auto, I believe he's currently out on pretrial for another felony, fleeing and eluding law enforcement, reckless driving, DWLS.
Is that correct, ma'am? He's on pretrial?
He's on pretrial pending a probation violation for that fleeing and eluding.
Okay. All right, your case that you're on pretrial for, sir, because of these alleged new offenses, I am vacating your right to be on pretrial, and I will sign that order. On the, is there any violence in his background that you have on the record?
Check.
Trying to find the word, it's revoking, isn't it? Or while he's looking, sir, I have revoked your pretrial abilities in the grand theft cases. You're gonna have to see the division judge on that. You also have a violation of probation allegation against you. That's a no bondable offense. You should see the judge on that probably on Monday. In the meantime, I'm still determining what to set the bond on the strangulation charge, but you are not to have any contact with Shantira Lical Williams until these cases are resolved, sir. You cannot contact her under any circumstances, directly or indirectly. Do you understand?
Yes, Your Honor.
Your Honor,
1 second, Mr. Romero.
I see no priors for violence. I would note, though, this allegation certainly is a heightened level of violence. I'd be requesting a $10,000 bond on one.
I see that.
And Judge, he did advise me he's not, this is his first violent offense ever. My understanding is the case that he's currently probation. He has no other, as far as criminal history, as far as convictions go. He was working at Checkers before, making $8.50. Unfortunately, he lost his job. Now he's looking. Based on the no bond holds, Judge, I'm asking for a $3,500 bond on Mr. Tanner's behalf.
Can I ask a question, Mr. Linder? On this
Certainly.
revocation of pretrial, do I set a bond on that, or is it Judge Garcia?
It's your discretion, Your Honor. Considering, though, that he does have a no bond on the VOP, I would ask that Your Honor place a no bond on the violation of pretrial, and Judge Garcia Wood can decide on both how to proceed.
So you're saying don't set a bond?
I'm asking that the court keep it a no bond, but it is within the court's discretion.
Well, the no bond is because of his VOP.
The no bond on count.
But I'm talking about when I revoke his pretrial, I can still set a bond, I'm just revoking his pretrial.
Yes, that
Yes,
is
you
within
can,
the court's
Judge.
discretion. I'm asking because.
I'm sorry, but Judge, that same case is what he's on
No,
the
Oh, okay. All right, I'm gonna leave it to Judge Garcia Wood on that case. In this case that's before me, on the VOP, you'll see the judge probably Monday, sir. I set the bond on the strangulation count at $5,000 with no contact with the victim. Good luck to you, sir.
Judge, what was the status of his pretrial case then? You just left it alone?
Yes, I said Monday, see Judge
it's
Garcia Wood.
revoked.
Oh, so you are revoking and holding him no bond on the pretrial, violation of pretrial,
Yes,
correct? Okay.
yes. Okay, Jonah Perez?
He's approaching, Judge.
Morning, Mr. Perez. You also charged this morning with domestic battery by strangulation and touching or striking during a domestic violence altercation. Give me just 1 minute, sir. Read your paperwork. All right, sir, there's probable cause to believe you may have committed both of these offenses. Are you working, sir? Are you working, sir?
Yes, I'm self-employed. I do mobile detailing. I've been doing it for about 3 years now.
How long you lived in South Florida, sir?
All of grade school.
You
I
have,
was born in Georgia then.
you have resources to post a bond in this case, sir? You have some,
I literally only have $120 that are in my wallet. Well, not in my wallet, but like when I came in here. I doubt that anybody else has money to give me to do this. And yeah, I don't know.
do you have a record, Mr. State Attorney?
Your Honor, he had a previous drug arrest that he successfully completed felony drug court on. Again, Your Honor, based on the level of violence and the physical injuries that would tend to corroborate the allegations, I'd be requesting a $10,000 bond, no victim contact.
And I'd just add that the victim in the
PC
case declined to provide a sworn statement.
The PC is different in this case than the other one. I see why they charged him with strangulation, but it's definitely different than,
And Judge, what I was further going to advise, Your Honor, is, as you heard, he's been here his whole life. He's working mobile detail. He's been doing that for about 3 years. But I mean, it's very limited income. Now, he does have family. He did give me the number of his sister. I'm going to be reaching out to her after court to see if he can help with the monetary bond. She's employed. She works at a local health spa. Her financial resources are limited. I'd ask you on count 2 on the misdemeanor offense to consider $1,000 bond. On count 1, on the felony offense, I'm going to be asking you to consider a $2,500 bond. That would be a total of $3,500, which the defense is requesting, Judge.
okay, based on the reading of the probable cause affidavit and taking into consideration both sides' arguments, I will establish the bond on count 1 at $3,000 and the bond on count 2 at $500, and also issue a no victim contact with Victoria Barcelona, it looks like. So that means you cannot contact her under any circumstances. You can't go to her house. You can't have anybody else contact her. And you really need to stay out of trouble if you post these bonds until you go see the judge to get these cases resolved, sir. Do you understand?
Yes, sir.
Anything else, Ms. Linder?
No, Judge.
Okay. All right, those are your bonds, sir. Good luck. Next. Are we ever going to get through this? I mean, the stack's just as high as when I started.
Eventually.
I shouldn't say that record. Jamal Griffin. Jamal, are you here? Yeah, of course.
Mr. Griffin, come on up, please. He's approaching, Judge.
This on this case?
Yes, Your Honor, this is a supplemental report. I provided a copy to Mr. Reedy.
All right, Mr. Romero probably hadn't seen it, but your colleague has. There's a supplemental report in this case. Sir, you were charged with burglary with an assault and battery, and there's a bunch of paperwork here, so give me just a minute. Oh, so this is on a warrant.
It's not in custody, Your Honor.
Yeah, this was, so the capias was issued by
It
Judge
was,
Salspector.
no, Your Honor, it was issued upon the state filing not in custody information.
Okay.
Pursuant to state statute, the clerk's office issued the not in custody
Okay,
capias.
gotcha. All right, sir, listen carefully to me. These are serious allegations. Appoint the public defender to represent you. Advise you not to say anything during the course of these proceedings about the alleged crime. I've read the first report. Do you have a record, Mr. State Attorney?
Well, Your Honor, if I may make a request before we get to that, if that's acceptable to the court.
Sure.
And there's a reason. Your Honor, the state, this is a punishable by life offense, and the state is going to be seeking, for first appearance purposes only, a finding of proof evident or presumption great, and that the defendant be held no bond so that an Arthur hearing could be heard before Judge Allspector, and the victims, if she so chooses, can address the court at that time pursuant to Marcy's law. Your Honor, the reason I provided the supplemental report, as you can see, the evidence against Mr. Griffin is not just the word of the victim, but there was another person in the home that advised law enforcement of the battery against the victim by Mr. Griffin, Your Honor. Relying upon the testimony by both the victim and the witness in the supplemental report, and Your Honor, I can advise you, a sworn statement was taken. I would be seeking the finding that I had requested.
Okay, who was the other witness? It says that Jules was in the home but did not witness the incident.
Your Honor, no, that's the child. I refer to the second paragraph. She's referred to in the PC, but if you look at the supplemental report, second paragraph, last sentence, Dominique Phillips.
Okay, I see. Okay, Mr. Reddy, Mr. Romero, want to say anything for me?
Yes, Judge, we would object to the court making a finding of proof evident presumption great at this stage of the proceeding. That is the highest standard of proof that we have in the criminal justice system. It's higher even than proof beyond a reasonable doubt. Apparently, these people gave statements. The state has decided that it's not necessary for them to produce those statements for the court to review, even though they're asking for this court to make a finding that they have met this very high burden. It appears that what happened here, and I think also the court does have the discretion to set bond, even if you do find proof evident presumption great, and I think that you should. It looks as though what Mr. Griffin was trying to do was to see his newly born daughter. I think she was just born a few days prior to this incident. For whatever reason, the alleged victim did not want him to see the daughter, and so he forced his way into the house, and that's the essence of the burglary, and that's what makes it a first-degree felony punishable by life. But it's not a situation where he was breaking in to steal anything, where he was breaking in with any other intent other than to see his daughter. So I don't know what's going on between these two people, but I think it's really kind of sad that I guess she was born actually in December.
Well, I think the difficulty in the PC, listening to, balancing what both of you all are saying is, I mean, he certainly had the opportunity, even after he came into the house to leave. They're saying that multiple times they asked him to leave, and he would not leave, and then it escalated into some degree of violence between the two. But forcing your way into a person's home under any circumstances, whether to see a child or not, is not proper and certainly can lead to a degree of danger. So I get your
I
argument.
don't disagree, Judge, but I do think that this is the kind of case where holding Mr. Griffin without bond, which is the most restrictive means of pretrial detention, would not be appropriate under these circumstances. So even if the court does find that proof is evident and the presumption of guilt is great, I would still ask the court to set bond for Mr. Griffin.
All right, Mr. Linder, last word. Anything else?
No, Your Honor.
I think I'll answer for myself.
You have something else you want to say?
Your Honor, two things very briefly. One, as far as that these statements weren't provided, it's not that I've decided not to present it. Your Honor, the 4th DCA in Esazavi State has determined that affidavits would suffice for the court to determine proof evident presumption great. Your Honor, as far as if the court should find that and not exercising your discretion, Your Honor, I would note that in 2017, Mr. Griffin was arrested for violating an injunction against the same alleged victim. Now, that charge was dropped. I would also note in 2012, he was arrested for domestic violence battery against a different alleged victim. That charge was dropped. In 2014, he was arrested for armed burglary of a dwelling. That charge was dropped. He was convicted last year for possession of methamphetamine, unlawful use of false name ID, 2011 grand theft. He was convicted of that and possession of cocaine with intent. Your Honor, because this actually involves someone's home, this wasn't a burglary with a battery of a car or even a business, but because this involves someone's home, I do believe it would be appropriate to allow this to go to an Arthur hearing where both sides can present testimony, both the defense, if they choose to call any witnesses, and the state can allow the victim an
All
opportunity.
right, I do agree with the state in this case. This is a very serious case, and certainly he could have left the room multiple occasions to leave before the provocation of physical harm occurred. A person's home is their castle, and These kind of violations can certainly lead to serious issues. I find proof evident presumption great. You can apply for a bond in front of the division judge. Under no circumstances should you make a bond or be released, or you to have any contact with the alleged victim, in this case, Jamara Tomey. Good luck to you, sir. Have a good day. All right, we're making progress. Carlos Vegas?
Spam.
Posted? He was posted, they said, Mr. Romero. He bonded?
Yes.
Thank you. Next is, I think we need to take a break in a minute, don't we? Next is Andre Knudsen.
He's approaching, Judge, here at me. Mr. Newton, come on up.
Is this an MO?
No, it's technically it's a traffic offense. It's panhandling, Your Honor.
But it's a state charge crime?
Yes, it is.
All right, sir, you're charged under, is this a capias? Yeah, under a capias for obstructing traffic. You don't have a permanent place to live, sir?
No, sir, me and my wife are homeless.
All right, you two have a couple pages of alias names.
No, they just spelled my name wrong because my name's spelled A-U-N-D-R-E.
All right, I'll take your word for that, sir. On this charge, on this capias, do you want to resolve that this morning?
Yes, sir.
Offer to be time served, Your Honor.
All right, the disposition will be time served. I'll withhold adjudication on the case. You'll be released, assuming you have no further cases, sir.
Thank you, sir.
Good luck to you.
Good luck, sir. Yep.
Withhold
John
adjudication
Green?
and time served. Am I allowed to do that?
Mr. John Green?
All right, we're going to do, Mr. Romero, we'll do Mr. Green, and then I need to let everybody here take a break.
Okay, no problem.
All right, Mr. Green, good morning. You're charged with trespassing. Okay, so this started off something about lottery tickets, but he ended up only getting arrested for trespassing. You want to resolve your case here today, sir?
Yes, sir.
Do you have a permanent address?
Yes.
You do? Where do you live?
672 Northwest 2nd Wing, Deerfield Beach, Florida.
And what's there? Is that a home?
Yes.
Who do you live with?
My girlfriend is our mother-in-law's house.
Okay.
Your Honor, obviously, I have no objection to the court resolving the case. I would just, I mean, it says he's been arrested for trespassing at this store 10 times.
All right. All right, sir, listen to me. I'm going to give you a chance to resolve this case without sending you to jail for 30 days under one condition. And that is you agree with me and tell me right here on the record while this proceeding is being recorded that you're going to stay away from this Abco Food Mart where they're telling me you have constantly gone back there and bothered the customers. Are you going to be able to do that?
Yes, sir, but, yes, sir.
No buts. I'm going to drive by there and make sure you're not there.
Sure, I can clean the parking lot. How am I trespassing?
You're cleaning
Your Honor, this has been brought up before, and judges have said, you can't go there. If you've been trespassed, you can't
All right,
go
well,
there.
I'll just put him in jail for 90 days and he'll stay away from there. Is that what you want me to do, sir?
You understand?
I mean, I can keep you away from Abco. I'll just lock you up.
No, sir.
All right, I can't emphasize with more degree of certainty than I am right now if other judges have told you the same thing. If you go back to that Abco and you get back into court, we're not going to resolve your case. We're going to send you to jail so you'll stay away from there. So you have to stay away, sir, okay?
Okay.
All right, I'm going to adjudicate him guilty on this charge of trespassing with time served, with the caveat that he stays away from this Abco Food Mart at 56 Northwest Eller Street in Deerfield. Don't go back there, sir, under any conditions.
Yes, sir, Your Honor.
All right, you'll be released, assuming you don't have any other cases. Good luck to you, sir. All right, we'll take a 10-minute break, guys, so we can use the restroom. Oh, let me turn this off. All right, Mr. Romero, we have our Spanish interpreter back.
Thank you, Judge, and we're ready to proceed on those individuals. First person would be on page 24 of the docket. That person's name is Mr. Brian Sands. Senor Sands.
How many pages are on this docket?
30.
I can never find anybody. Sands, you said.
S-A-N-Z, Correoso.
Got it. All right, Mr. Interpreter, you'd raise your right hand. You
Yes,
swear
sir.
affirm any testimony taken during these proceedings will be accurately translated from Spanish language into English?
I do. Guillermo Sinisi, certified court interpreter.
All right, sir. Mr. Sands, you're charged with 2 cases,
Señor Sáenz es acusado de 2 casos,
grand theft
hurto mayor
and burglary of an unoccupied conveyance.
y allanamiento de un vehículo desocupado.
Give me 1 second, sir.
Un segundo, por favor, señor.
All right, there's sufficient probable cause to believe you may have committed one or both of the offenses.
Hay suficiente motivo fundado para creer que haya cometido uno o ambos delitos.
Do you have a permanent address in South Florida, sir?
Señor, ¿tiene una dirección permanente en el sur de la Florida?
Sí.
Yes.
And what city is that and how long have you lived there?
¿En qué ciudad es y por cuánto tiempo ha vivido usted allí?
Miami, Florida, 10 años.
Miami, Florida,
10 years.
Does he have any record, Mr. State Attorney?
Señor fiscal, ¿tiene antecedentes?
He had a grand theft in Dade County in 2013. It was
Hurto mayor en el condado de Dade en 2013
it was dropped after he successfully completed pretrial a diversion program.
y fue desestimado después que completó exitosamente el programa divergente del proceso judicial.
Are you working, sir?
Señor, ¿está trabajando?
Sí, yo trabajo vendiendo y comprando herramientas.
No lo entendí. ¿Usted trabaja dónde?
Sí, vendiendo y comprando herramientas.
Yes, I work buying and selling tools.
Judge, if I may, I have additional information. He actually lives with his father in Miami. His father is the person that he's going to be contacting to help post his monetary bond.
Si yo puedo interferir momentáneamente, señoría, tengo información adicional. Él vive con su padre y el padre es el que él va a estar contactando para poder pagar la fianza monetaria.
Now his father is employed. He works for a local, it's called the Bread Flour Bakery, where he sells bread, Judge.
Sí está empleado su padre, trabaja en una compañía local que se llama Red Flour Bakery, donde venden pan.
And my understanding, Judge, his father has limited access to finances, so therefore I'm going to be asking for a $1,000 bond on count 2, along with the $1,000 bond on count 1. We're asking for a total $2,000 bond on his behalf.
Y señora, entiendo que él tiene acceso limitado a finanzas, el padre, así que vamos a estar pidiendo $1,000 de fianza para el segundo cargo, $1,000 de fianza para el primero, por un total de $2,000 de fianza.
And his father is present, Judge.
Y el padre sí está presente.
That's not his father.
Ese no es el padre.
Are you Mr. Sands' father?
No, that's not his father.
Oh, okay.
Never mind.
All right. Okay, I find probable cause in the cases. I set the bond at $1,000 on count 1, and I set the bond at $2,000 on count 2. Total bonds will be $3,000. And you are to stay away from this area where this incident occurred, which is Northwest 105th Way and Northwest 10th Street. Do you understand, sir? Can you translate that?
Yes, sir, I'm writing everything down.
I'm sorry, thank you.
Voy a fijar, como dije, dictamino que existe motivo fundado. Voy a fijar la fianza para el primer cargo en $1,000, para el segundo cargo va a ser $2,000 y le ordeno que se mantenga alejado de esta área, que es noroeste 105 camino y la 10 camino.
You understand, sir?
¿Entiende, señor?
Sí.
Yes.
All right, good luck to you, sir. Have a good day.
Suerte, señor, que tenga suerte. Que tenga buen día.
Judge, the last person that requires a Spanish interpreter is on page 27. His name is Mr. Guillermo Sosa Peralta.
Got it.
Sosa Peralta.
Sir, you were charged this morning with aggravated assault with a deadly weapon without intent to kill. Give me 1 second.
Señor, es acusado de agresión agravada con un arma mortífera sin la intención de matar. Deme un segundo.
These are serious allegations, sir. I appoint the public defender to represent you.
Señor, estas son alegaciones serias y voy a nombrar la oficina del abogado público para que lo represente.
How long you lived in South Florida, sir?
Señor, ¿cuánto tiempo ha habido en el sur de la Florida?
13 años.
13 years.
Thank you. And do you work?
Judge, if I
¿Y
may.
usted trabaja?
Yes, Mr. Romero, go ahead.
Adelante, señor.
Judge, he's right now currently looking for work. He was previously working in construction where he made up to about $130 a day.
Señor juez, él está buscando trabajo. Él previamente estaba empleado en el área de construcción, en el cual hacía aproximadamente $130 al día.
Now, he does live here locally where him and his wife rent an apartment where they've been living at for the past 4 months.
Ahora, él sí vive aquí, en el área donde vive con su esposa en un departamento que han estado alquilando los últimos 4 meses.
Now, my understanding is the total rent is about $1,000, and right now his wife, who's employed, is basically taking on the whole financial burden of the household.
Ahora entiendo que la renta total es $1,000 y la esposa, la que está empleada, se está ocupando de la carga total económica.
Now, she works for a local insurance company. He doesn't know exactly how she makes, but that's the person that he's going to be contacting to help post his monetary bond.
Ella trabaja para una compañía de seguro del área, no sabe exactamente cuánto es lo que ella gana, pero esa es la persona que él va a estar contactando para que se pueda pagar la fianza.
Now, I believe, Judge, the alleged victim to this incident was a person that lived at the apartment, but from my understanding, that person now has moved out.
Ahora entiendo, su señoría, que la alegada víctima de este incidente es una persona que vivía en el mismo complejo de departamento o el de departamento, pero esa persona ahora se ha mudado de allí.
Now,
Mr.
he
State Attorney,
does have prior contact with the system, but I believe this is the first violent offense.
Sí tiene contacto previo con el sistema jurídico, pero entiendo que este es el primer delito violento.
Mr. State Attorney.
Thank you, Your Honor. Mr. Sosa Peralta's history includes a theft last year,
Incluye un hurto del año pasado, en los antecedentes,
grand theft 2017.
un hurto mayor de 2017,
He violated probation, was sentenced to a year and a day state prison.
violó la probatoria y fue sentenciado a 1 año y 1 día a la prisión estatal.
Grand theft in 2016 where he violated probation.
Hurto mayor también en 2016 en el cual violó también la probatoria.
All right, well, this is pretty serious what they're claiming he did here. The victim did not get injured. No matter what I do, sir, under no circumstances are you to have any contact with Gino Latorre.
Son muy serias alegaciones aquí, es muy serio lo que se indica que usted ha hecho aquí, alegadamente. Bajo ninguna circunstancia debe usted tener contacto con Gino Latorre.
He's had contact with the criminal justice system in the past.
Ha tenido contacto con el sistema jurídico en el pasado.
I understand your argument, counsel, but because of the serious nature of this, I am going to set the bond at $5,000 in this case. You'll have to post that bond, have no contact with the victim.
Sí entiendo sus defensas, señor abogado, pero por la naturaleza seria de las alegaciones voy a fijar la fianza en $5,000 y no puede tener contacto con la alegada víctima.
All right, sir, have a good day. Good luck to you.
Que tenga buen día, señor. Buena suerte.
Daniel.
To my knowledge, no one else here requires a Spanish interpreter, but I don't know if the other facilities require a Spanish interpreter.
Anybody listening on the other facilities need a Spanish interpreter? Hearing none, thank you very much, sir, for coming in.
Have a good day.
I have a family member here on a case, page 20.
Yes, Judge, Mr. Etta on page 20.
Your Honor, I'll wait till Mr. Etta gets to the podium, but before we get too far into this, I have a request.
Okay.
Mr. Etta, come on up, please. He's approaching, Judge.
Anybody know what, oh, you said page 20. Daniel Etta. All right, before we get, you speak English, sir?
Yes, I do.
All right, before we get too far, the state attorney wanted to say something while I'm reading the paperwork.
Your Honor, actually, I was going to be asking that this matter be reset for the PM. This is a filed case. There are multiple supplemental reports, a sworn victim statement that I plan on preparing to provide to the judge for this afternoon to review, Your Honor, in advance of the afternoon hearing. Obviously, I'll provide copies to the defense, but as you can see, and I'm making this request because as you can see on their nature, these are very serious allegations. I believe in your findings, it says burglary of an occupied structure, Your Honor.
Yes.
It should be burglary of an occupied dwelling. This was the victim's home.
It does says burglary of a dwelling occupied.
Oh, okay, I wasn't sure. I know in the KPS it does, on my booking it says structure,
No,
so I
you're right,
wasn't sure.
you are right about that.
So, Your Honor, I would be, and I understand, and if the court is inclined on this causes father any inconvenience, I do apologize, but I think with these type of allegations and an
Well, I
abundance of
think you're
caution.
entitled to have all of the stuff to the public defender so they can see what you have. Sir, I know it might be an inconvenience. It is 10:30. The afternoon docket starts at 1. Is it possible you can come back at 1 o'clock?
Yes, I will, sir.
All right, I apologize for the inconvenience that certainly nobody knew. I am going to ask, as I would the public defender if they asked me the same thing, so that everybody can look at the evidence that might be presented against, I guess this is your son?
Yes.
Uh-oh, we
Yes,
lost
yes.
the feed here. We lost the feed.
It's back.
Oh, so I'm going to reset this at 1 PM. So if you come, I will put the paperwork on top, and I'll ask the,
Your Honor, I will contact Judge Lopane's judicial assistant to get him the paperwork
all right.
as early as
We'll
possible.
ask him to do the case first. I'll try to get a text to him, okay? So you don't have to wait any further.
Thank you.
So if you come back at 1 o'clock, all right?
Thank you, Your Honor.
1 PM. Thank you very much, sir. Should I keep this over here, or you keep it? Just ask if you can, Judge Lopane, to do that one first, so that guy doesn't have to wait again. All right, so we just go back to the regular order? William Ward?
He's North Broward, I believe, Judge.
William Ward, is that you?
Yes, sir.
You're charged with petty theft, sir,
Yes, sir.
at a Walmart,
Yes, sir.
$99.13. The items were photographed and store wished to prosecute.
Mr. Ward would like to resolve this case, Judge.
Okay,
And
we'll see
Your-
what we can do.
The offer from the state would be an adjudication time served. The adjudication conviction is based on the fact that Mr. Ward has been to state prison on numerous occasions.
All right, sir, based on what the state is telling me, they're asking me to, if you want, to adjudicate your case, which would mean I'd find you guilty on the petty theft charge. The sentence will be time served, assuming you have no further warrants or holds. You'll be released from the county jail. The merchandise was recovered. Do you wish to do that?
Yes, sir.
All right, I'm going to adjudicate you guilty on the charge of petty theft. I'm going to sentence you to time served, and I'm going to tell you, you cannot go back to this Walmart where this crime occurred, which is at 2500 West Broward Boulevard. Stay away from that Walmart, sir, okay?
Yes, sir. Thank you, sir.
Good luck to you, sir. Have a
Good
day.
luck, man.
Yes, sir.
All right, next case is
Very.
Jonathan Berry.
He's a North Broward judge. He'd like to resolve this charge today.
Thank you. Mr. Berry, oh, I'm bringing him.
Morning.
Morning, Mr. Berry. Mr. Berry, you're charged with 2 cases this morning, trespassing and criminal mischief, $200 or less. Let me see what they say you did. All right, sir, this is not appropriate behavior. I don't know if you did this or not, but you're not supposed to be doing this. You want to resolve your case, huh, sir?
Yes.
Okay, you're going to stay away from doing this?
Your Honor,
Yes.
I'm sorry. I would ask that this matter not be resolved because of the criminal mischief, there could be restitution issues.
He spit on a camera.
And I don't know if the camera was damaged, but certainly under Marcy's law, the victim has a right if there was restitution to be heard. I'm not suggesting, I'm not even saying that the court has to keep him in custody. Just asking that the case doesn't have to be resolved today. There's a victim.
Sir, do you have a permanent address where
He
you
does,
live?
Judge. I've spoken with his mother.
All right. All right, here's what I'm gonna do. I'm gonna ROR you on these charges, but I'm gonna require you to go see the division judge to get the matter resolved. I don't know whether there's any restitution, and he is right about Marcy's law. I don't wanna take a chance. So right now, sir, I can't resolve your cases, but I am gonna ROR you, assuming you don't have any other charges or holds. How long you lived in South Florida?
Well, I'm 20 years old now, so I've been living here since, I think, honestly, I've been living here my whole life.
Okay. Are you working?
No, not now.
All right, well, you need to be working, you need to be a productive citizen, and if you did what they said you did, you need to stop this. This is unnecessary and just clutters up the court dockets. What's gonna happen is, I'm gonna release you on your own recognizance this morning, as I said, assuming you have no other charges or holds, which means they're gonna let you out of the county jail, but that doesn't mean I'm dismissing these cases or disposing of these cases. You have to come to court and talk to the judge and get them resolved in the courtroom. It's your obligation to find out when your court date is and to show up here in the courthouse. If you do not, a capias will be issued for your arrest, and the likelihood is you'll be held in the county jail until your case is resolved. So make sure you find your court date and come back to court, all right?
I would like a lawyer.
You probably get a lawyer when you come to court and you fight these charges. I don't know what your financial resources are, but you can make application for the public defender to represent you.
And Your Honor, the only other thing I request, I note they're neighbors. I just ask that if you could order Mr. Berry to have no direct or indirect contact with the victim and not to enter the victim's
These are his
property.
neighbors?
Yes, I'm looking at
All
the
right,
two
I see that,
residencies.
I see their names. So you're to stay off the property of this Karen and Rotello, looks like Portolan, which appears to be your next door neighbors. You stay off their property unless they've given you permission to be on there henceforth. Do you understand?
Yes.
If you go on their property, you could violate the conditions of your release, so don't do it, sir. Stay out of trouble, get this case resolved. You can make application at the public defender's office for a lawyer if you don't have resources, and they'll represent you when your case comes up. Okay? Good luck to you, sir.
And listen to your mother, Jonathan.
Will do.
What are you guys here on? Are you just watching, right? Judge Lee? Oh, yeah, he's taking another busman's holiday this week. He's off having fun at a conference. I like Judge Lee. He's a great judge. And see, I said that while this thing was on, so you can show him I said that. Markunkel? DeSorosis?
Here, present judge at Maine, approaching Mr. DeSorosis. Come on up, sir. Maine.
Oh, thank you. All right, this is another one. Shouldn't be in the court system. You're charged with touching or striking during a battery. It says that suddenly attacking and hitting an employee of a McDonald's in the work area.
It's like they were
Employees.
both employees, I think.
All right, well, this is ridiculous, sir. You're employed and you're getting in a fight with another employee and you're getting arrested? How long you lived in South Florida?
All my life. Clean record, judge.
All right, sir, listen to me. I'm gonna, because there's no injuries here, I'm gonna release you on your own recognizance on this charge. That doesn't mean that the case is dismissed. You have to come back to court and resolve this case with the judge through whatever means. In the meantime, you are to have no contact with this Derek Jackson at all, under any circumstances. If he works a certain shift and you're still working there, then you need to work on a different shift so you don't have any contact with him. Stay away from him until this case is resolved through the court system. Do you understand?
Yes, Your Honor.
All right, you'll be released on your own recognizance, assuming there's no other charges. It is your obligation to find out when your court date is and to come back to court, sir. It's not the public defenders or your brothers or your mamas. It's your obligation. If you don't come back, we'll issue a warrant for your arrest.
Understand? Yes, Your Honor.
All right, good luck to you, sir.
Good luck, sir.
Next is Joseph Curtis.
Mr. Curtis, come on up, please.
Mr. Curtis charged with trespassing.
Please approach, Judge.
All right, sir, you're charged with trespassing at a 7-Eleven. They're saying you're bothering the customers. Do you want to resolve your case, sir?
Yes, I would, Your Honor.
Okay, the only way I'm going to resolve your case is if you tell me, while this blue light's recording, that you're not going to go back to the 7-Eleven on Wilds Road and bother the customers.
No, sir, I will not.
All right, I'm going to adjudicate you guilty if that's what you want to do of the trespassing charge. I'm going to sentence you to time served on the offense with the caveat you don't go back to the 7-Eleven. I'm going to come by there and see if you're there, all right?
Okay, yes, Your Honor.
All right, behave yourself, sir. Good luck.
All right, thank you.
I got a lot of places to go tonight, check up on some of these folks. Kelly Figueroa.
North Broward.
Figano?
Yes, Your Honor.
How do you pronounce your last name?
Figaro?
Figaro, okay, it's not that hard. So you're charged with providing false, what has he done? False information? False verification of ownership to a secondhand dealer at a GameStop. Receive money from the GameStop or goods, $160 for an item. Count 3, dealing in stolen property. Oh, this is an 18 charge. This is 17 and 18 add-on.
That's right, Your Honor. Mr. Figaro has no bond holds on several other counts. I would ask the court to leave the bonds in place where they are. Mr. Figaro is very anxious to get in front of his division judge. I'm hoping that we can arrange for him to appear in front of his judge on Monday.
All right, I will agree with you. Find probable cause in both cases. Leave the bonds as they are. 1,000 and looks like 3,500 or 3,000?
3,500, Your Honor.
All right, your bonds will stay the same as the convenience bond schedule, sir. Hopefully you can get these cases resolved, all right?
Thank you, Your Honor.
Good luck to you, sir.
Thank you.
Myril Siminoff,
Please approach, Judge Jeremy.
does he want to resolve his case?
No, Judge, I believe he has outstanding no bond holds on the other matters, Judge.
Okay.
Yeah, this is actually count 8.
Oh, forgive me. Okay, count 8. Criminal mischief is your charge on this case, sir. Give me 1 second. Okay, damage to vending machines. There's probable cause. I'll leave your bond where it is on this case, which is $500. So you'll have 8 cases you'll have to resolve with the judge. Where did he go? He leave? Oh, he's in the main jail, no wonder. All right, Mr. Siminoff, I'll leave your bond at $500, find probable cause. You'll have to get all these cases resolved with the division judge. Good luck to you. Yeah, just give me a minute. I'll get with you.
If I could ask, I don't know if Mr. Reedy could look in Odyssey. I know he's being held on other matters. If he knows when his future court date is or anything like that, that's what he's asking.
Send a message through the kiosk. All right, and they'll find it at the court date, but we'll look real quickly while I'm looking at the next case.
Thank you, Judge. I appreciate that.
Just tell the deputies to hold him there a minute and have his seat and,
Your Honor, I've got it right here.
oh, he's got it, never mind.
It takes 2 seconds.
I see he was just before Judge Merrigan on July 10th to set new dates, and he got a calendar call August 12th.
All right, August 12th sounds like.
Thank you.
August 12th.
Thank you very much.
Thank you.
All right, the next case, Justin Cordell
Roberson?
Roberson. These are also add-on charges, count 4 and 5 on grand theft from a Sam's Club, it looks like. All right, there's probable cause to believe he may have committed these last two offenses. And I will leave his bonds as they are on the convenience bond schedule. In count 4, the bond is 1,000, and in count 5, the bond is 1,000. You'll have to see the judge, sir. Good luck to you. Jaquez Dillard,
He's approaching Judge Chairman.
just a few minutes, whoever hears on that RPO, just give me a minute, I'll get with you.
On this case, count 4 should be a conveyance, Your Honor.
Count 4 is amended to be a conveyance. This is counts 2, 3, and 4, so he's been here for something else. Charged with burglary on an unoccupied conveyance, petty theft in the first degree, and burglary of an unoccupied dwelling, correct, Mr. State Attorney?
That is correct, Your Honor.
Entered the mailbox of the victim. It's apparently video footage. All right, there's probable cause on all 3 cases here today, sir. Do you have a record, Mr. State Attorney?
Well, Your Honor, I'm requesting a $5,000 bond on count 1, noting it was the curtilage, $1,500 bond on 4. He's got no bond out-of-state hold.
He's got a no bond out-of-state hold?
Yeah, that's correct.
All right, well, you're not going to go anywhere till you get that no bond out-of-state hold resolved, sir. Which count were you requesting the bond on, sir?
5,000 on the 2 on the dwelling, 1,500 on the 4 for the conveying the car.
The count 1 was the car, or count 4?
The first count is the dwelling.
Right.
The last one is the car.
All right, on count 2, I set the bond at $2,500. On count 3, on the petty theft, I'll set the bond at $100. And on count 4, the burglary of the unoccupied vehicle, the bond will be $1,500. Those total bonds are $4,100 in addition to whatever else he has pending. Good luck to you, sir. Next is Anthony Joseph.
Mr. Joseph is approaching Judge, and he declined to serve as a public defender.
All right, good morning, sir. Don't say anything about your case, because this is, don't say anything about your case, because this is recording what you say. You're charged with 5 cases today, burglary of an unoccupied conveyance, 2 allegations of violated community control, and 2 allegations of violating your probation. Give me 1 second. All right, there's probable cause on the burglary count. I'm going to set your bond on the unoccupied conveyance count 1 at $1,500. On count 2, there's no bond. Count 3, there's no bond. Count 4, there's no bond. Count 5, there's no bond. You will have to see the division judge on those counts probably Monday morning, Mr. Joseph, Monday morning. Good luck to you, sir.
Appreciate it.
Peter Metzler. Are those parole violations, no bond, Mr. State Attorney?
I'm sorry, on who?
A parole violation, so no bond?
It is, Your Honor. It's for the parole board to come down here.
All right, Mr. Metzler, you're charged with 2 cases, petty theft in the first offense, which is not a very serious offense.
Okay.
Relating to something that occurred at a pharmacy. But they have alleged that you violated your parole as a result of this charge, which is a no bondable offense. Should you make this bond or should you be released, you're not to go back to the Publix on Dania Beach Boulevard where this incident allegedly occurred. On count 1, I'll leave the convenience bond where it is at $25, but you're going to have to see the parole board, you'll be held until you see them, sir, all right? Good luck, good luck to you, sir. Let me do one more. I've got an RPO here in the courtroom I need to do real quick also. John Doyle Hilson.
He's here, President Judge, I mean.
All right, Mr. Hilson, you got a whole bunch of charges here today. I'll appoint the public defender. Don't say anything about your cases. All right, you're charged with 6 counts, possession of methamphetamine, drug paraphernalia, and then you have 3 warrants relating to pretrial violations of probation. That's right, right? VOPs?
No, there are violations of pretrial.
Just violations of pretrial. There's probable cause based on the police affidavit. Okay, so on the pretrials, there's already probable cause established by the warrants. Is he, okay, so he's been, no bond has been established by the division judges on those counts, correct? Judge
Yes,
Lynch?
yes, Judge.
Those
Judge
are old
Lynch.
warrants. Judge Lynch hadn't been over there in a while. Okay, so these are older warrants. Counts 4, 5, 6, there's no bond established by the division judge. Counts 1 and 2, the bond will be $1,000 each and $100 on the drug paraphernalia charge. You're gonna have to see the judge over there, sir, and get all these warrants taken care of and resolved before you're gonna be free, okay? Good luck. All right, one more, and I gotta do this ROP. Do you know, is this guy gonna fight this ROP? Is it gonna be an evidence case?
It's likely, Your Honor, and he's going to be appearing by.
Yeah, I heard. I still got good 20 more cases to do.
It's up to you. We're here on your dime.
All right, let me, Joe, can you call Mercedes? Does she have his phone number?
I got the best number for you to reach him.
It's here? Give it to Mercedes. I'm gonna have Mercedes call the guy, tell him it could be another 30 minutes before we get with him, so that he doesn't think we've forgotten. On Jonah Riley,
Medical reset, Judge.
med reset, thank you. How about Lukens Pierre?
He's approaching, Judge, here, man.
All right, good morning, sir. You have some issues also. You're charged with driving while license suspended and a habitual offender, and you also are charged with violating your probation. There's probable cause on both cases. You're gonna have to see your division judge on Monday, see if you can resolve your VOP case to get out of custody, all right?
Thank you, Judge.
One second. So, 1 second, what?
The case number for count 2,
Yes?
there's too many numbers. It should be case number 1801195.
Okay, so
156.
corrected. I've made the correction here.
You left off the 6. Just one 0 needs to be crossed off.
18-01195.
6.
Oh, 96.
CF10A.
Got it. Okay, it's corrected. All right, sir, good luck to you. You'll see your judge on Monday. How about Stefan Sweet?
Mr. Sweet, come on up, please.
All right, sir, you're charged with grand theft, looks like a phone of some kind, and there's a capias on a traffic offense.
Is he getting an ad charge for a VOP?
This is looking like it says you gave them a bunch of $50 bills that look the same. All right, there's probable cause in both cases. Capias on the traffic. It's like you didn't appear in court to answer for failing to register a motor vehicle. Did you once live at 26340 Northwest 52nd Avenue, sir?
Yes. Your Honor, just to advise the court, I saw and I confirmed with the confinement status, Mr. Sweet is going to be ad charged with the violation of probation warrant out of Punta Gorda, and there's a no bond hold on that.
VOP Punta Gorda. All right, that's bad news, sir, for you, because they're telling me there's a VOP out of Punta Gorda. You'll probably be held no bond on that, As to these two charges, on the grand theft charge, the bond is established at $500. And on the traffic capias, the bond's already established at $100. You'll have to post those bonds, but they'll probably bring you to Punta Gorda to answer that other case. All right? Good luck to you, sir. Danielle Montejeo?
He's approaching Judge here at Maine.
All right, sir, you have a bunch of cases too. I'll appoint the public defender to represent you. Don't say anything. You have a charge of possession of cocaine, possession of a Lazarpan, drug paraphernalia, a violation of probation, or community control 2 times. Look at the current charges. All right, there's probable cause on the other 2 cases. I'm gonna set your bonds. Does he have a record? I guess he does, because he's got a BOP.
Yeah,
It's the last thing he had in the last 2 years.
one moment, Judge. Your Honor, I don't see necessarily anything in the past 2 years. I think the concern is it appears he absconded, and I do see an arrest in Puerto Rico in 2016, which would have been after the warrant was signed by Judge Rothschild.
All right, based on that, I'll leave the bonds where they are. On count 1, the bond is $1,000. Count 2, the bond's $1,000. And count 3, the bond is $100. On the last 2 charges, they're violations of probation. You'll see your division judge probably on Monday, sir. You'll have to resolve those cases there. Good luck to you. I don't know if I got these out of order here. Is it Nicholas? N-E-L-O-M-S, is that the next case?
I had Haberly. Oh,
Haberly, okay, I got him out of order, right. Gary Haberly.
yeah,
Med Reset, thank you. How about, is it now,
Tukes and then Nicholas Nellums.
thank you. Got him out of order here. John Tukes.
He's approaching Judge here at Maine.
All right, good morning, Mr. Tukes. You're charged with 2 cases, possession with intent to sell or deliver cocaine, and tampering or attempting to destroy evidence. Give me 1 second, sir. All right, this doesn't look very good. All right, sir, there's probable cause on both cases. Do you have a record, Mr. State Attorney?
Your Honor, just, he's got a pending possession of Utilone, a controlled substance. It's obviously within the court's discretion whether to revoke on that. He was actually just ROR'd in June, mid-June of this year by Judge Colra after he was taken into custody for failing to appear on that case.
I'm going to revoke his bond if there's cocaine all over the floor, they're saying in this case. This is pretty big trouble, it looks like. Mr. Tukes, I'm going to leave your bonds where they are here at, is that $3,500, counsel? $2,500 on count 1, $1,000 on count 2, but I'm revoking your bond in the other case, and the state attorney will give me an order on that.
Is that a no bond hold for Judge Colra too?
Yes.
Okay.
Good luck to you, sir. Stay out of trouble. Nicholas Nellums, N-E-L-O-M? Bonded. Thank you, counsel. Bonded. Fritz Poulard.
He's approaching Judge here at Maine.
All right, good morning, sir. You're charged with a minor offense, petty theft, which there's probable cause on. However, you're also charged with 2 counts of probation violations. I'll leave your bond at $25 on count 1. You're going to have to see the judge Monday on your 2 violations of probation allegations. All right, sir?
Thank you, Judge.
Thank you. Good luck. Cody Radley?
Bonded.
Thank you. And almost there, Van Vliet? Nathaniel?
Van Vliet is here present, Judge approaching.
So you're charged with burglary of an unoccupied dwelling and also petty theft. These are based on warrants. Therefore, there's probable cause. He's got a no bond hold here.
These are, it's hold for magistrates, Your Honor.
Oh, hold for me, okay.
Yeah, I'm just looking at the booking. I don't know who Judge Anderson is. But
Okay, it's a Sony PlayStation and a digital camera at a residence.
From 2016.
Yeah.
And Your Honor, I would note, it's one thing if an incident happens in 2016 and the state doesn't file for a long period of time. I believe this was filed in 2016. Law enforcement has been unable up until now to locate him to serve the warrant.
Sir, what ties do you have to Broward County?
Judge, if I may, Judge, he's been here his whole entire life. He's 43 years old. Right now he is working. He just got a new job. He works at Trans Vans Lines. He's been there for about 1 month. That's in Hollywood. He makes about $500 per week. Now, he's the provider of his girlfriend and his child. They don't live together. They live apart. My understanding is the girlfriend is not working. She collects food stamps, so she's really not much in a financial position to post his monetary bond. Now, this incident happened, as you can see, about like almost 4 years ago, Judge. And I believe during that time span, it was a situation where she was living there, and unfortunately he was kicked out. He had a huge drug issue at that time. Since then, now he's been clean 3.5 years, drug-free. He lives locally here in Hollywood. He lives in a local recovery center where he's been there living for the past 3.5 years, and he's proud to say he's clean and sober now. And he hasn't had contact with the criminal justice system since then, Judge. So, Judge, considering I do not believe he's not a flight risk, he is going to be coming back to court. This is almost 4 years old, Judge. I'm going to be asking if the court would consider setting a $1,000 bond on count 1, ROR count 2, so that somehow his girlfriend can come up with that monetary amount.
Your Honor, the one thing I could advise you, if he's been residing at this residence, that Mr. Romero mentioned, recovery residence, for the past 3 years of this Hollywood address, which is, I think the location, it's the same as the permanent address, or close to the permanent address on his booking sheet. I can imagine why law enforcement wouldn't be able to locate him, because that was just updated on his DHSMV April 1st of this year. There had been no updates. The most recent update prior to that was in 2013, so law enforcement would have had no idea.
Well, okay, listen, the thing that concerns me is nothing that you've said, Mr. Romero, that he's trying to be a productive citizen, but this crime that they're alleging occurred during this period of time, he's claimed to have gone in the residence through a window and stole his property. That's pretty serious when you enter somebody's residence. That is a violation to the victim, at least, of their home. So I'm happy to hear that he's cleaned himself up, and I'm going to give him an attempt to continue to do that, but he's got to get this charge resolved. I'm going to set the bond in count 1 at $1,500, and in count 2, the bond is $100 on the petty theft. Those will be the total bonds. You'll have to post those bonds, stay out of trouble, and continue to be employed, sir. Good luck to you.
Thank you, Your Honor.
Next is Andrew Watson.
He's approaching, Judge. He's the
Yes.
main.
He has already posted the bond on count 1.
Okay, they say you posted the bond on count 1 on the marijuana charge, so there's probable cause, the bond is posted. Count 2 is something to do with windows. Is that a traffic offense?
It is an infraction.
And the next
2
one
and
is
3 are
also a
infractions.
traffic offense, and the last one is VOP?
Yes.
All right, you got a no bond on count 4. On the other 2, the bonds are 0, so your only bonds are $100. You're gonna have to resolve that violation of probation case, Mr. Watson. You'll probably see the judge Monday morning. All right, sir? Probable cause on all cases. Good luck to you, sir. Good luck. Anthony Fabian?
Mr. Fabian is approaching, Judge, and he declined to serve as public defense.
But did, on count 1? Yes. All right, sir, they say you posted bond on count 1 DUI third offense. Wow. You're also charged with threatening a public official or public servant, resisting an officer, obstructing without violence, unlawful speed, possession of open container. You have the resources to hire a lawyer, sir?
I do not.
How long you lived in Broward County?
12 years.
Your Honor, did Mr. Fabian say he does not have the resources to hire an attorney?
What he just said.
I would note, he says he's driving his vehicle's a 2013 Mercedes, and when law enforcement interviewed him, he said he was leaving from one of his homes to go to another one of his homes.
Well, he'll have to get him a lawyer, I guess, or represent himself, which he has the right to do. Okay, there's probable cause in all 5 of your cases, sir. They say you posted bond on count 1. Let me look at this allegation on count 2.
Oh, cash bond. Oh, and he also told law enforcement he's rich.
Yeah, he said some bad things at the scene. Maybe the alcohol was, hang on, sir. Let me talk. There's no reason for you to say anything, because you can't, I'm not here to decide whether you did any of this stuff. It's just here to decide release conditions.
Okay.
Okay, he did not follow some of the police officer's orders, but maybe when you're alleged to be intoxicated, you don't. I don't know. All right, it doesn't look to me, Mr. Linder, very serious.
Well, no, Your Honor, the allegations that make up count 2,
Yeah.
I would direct the court to page, it wasn't for his failure to follow instructions, it's page 1, 2, 3, 4, the last paragraph, and what he advised he would do to the officer if he was not let go.
What am I missing? I don't see it.
Did you see the last paragraph on the 4th page after I placed him in the back of my patrol vehicle?
Yeah, that's what I'm reading. Let me read all of it. Yeah, I see what he said. Okay, very good. I'll set the bond in count 2 at $1,000 and count 3 at $500. The other 2 are traffic offenses. So you're gonna have to find somebody to post another $1,500 to get out of custody and see the judge and get these cases resolved,
Your
okay?
Honor,
Yes?
what I would be requesting, considering this is a third DUI, is in addition to bond, pretrial release with a TAD monitor.
TAD?
TAD. That would, if he drinks, the monitor will go off. No alcohol or intoxicants in random testing.
Okay, no alcohol, no intoxicants. I will require you to report to pretrial release upon release and get a TAD monitor. And what else was it?
They'll put on the monitor before he's let released from custody.
Before he's gone?
Yeah.
Okay.
And that's it. Yeah.
All right, those are your conditions of release, sir. Do you understand?
I do.
Okay, this is your alleged third DUI. You can't get in trouble anymore, sir. Next time you're gonna go to jail, okay?
Yes, sir.
All right, good luck to
Those
you.
were very old.
It doesn't matter. Good luck to you, sir. All right, next, Mr. Romero. I don't see anybody left. They must be at the other place. Michael Savage.
He bonded, Judge.
Thank you. Clive Gregory.
bonded.
COQ, bonded also, thank you. How about Scott, or Yorick Scott,
He's a medical leave
Medical.
judge.
medical reset? How about Jeannie, Geanny, immigration hold,
Medical.
medical reset, thank you. How about Matthew Komashak?
Medical reset, Your Honor.
Thank you. Almost there, one more. AVILES, Aviles?
Medical reset. Medical reset.
Thank you. And Monty Blaylock, Blaylock?
Medical reset also.
Thank you. And Alex Legrell?
He's here, present, Judge, at Maine.
Your Honor, this is a case that was up for perfection for proof evident or presumption great. I imagine Your Honor would like an opportunity to read the report first.
All right, sir, these are very serious charges. I appoint the Office of the Public Defender to represent you for this case and all other purposes, assuming you qualify. You're charged this morning with, or maybe on a return this morning, on a lewd and lascivious allegation of molestation of a child under 12 years old.
Your Honor,
Okay, so this has been up, and Ernie did not find proof evident.
Judge Carl did not find proof evident or presumption great, Your Honor. I spoke with Detective DeGeorge, who prepared the probable cause affidavit. I have no new factual information to provide. That being said, Your Honor, the state would renew its objection to Judge Culver's finding that proof evident or presumption great does not exist.
This has one of the siblings as a witness to what was going on.
Your Honor, I
All right.
argued that.
All right, I'm the chief judge. I
No,
can change it. I can change release conditions.
The
Mr.
only
Reddy?
thing I can say, Judge, is that this matter was reviewed by a magistrate judge yesterday. Judge Collier reviewed the same information that is in front of the judge now.
So how does he end up
Absolutely
back
nothing
here?
else has been presented.
How does he end up back here?
Your Honor,
Because the state asked for 24 hours to perfect, and they haven't perfected. They haven't done anything except hand you the same probable cause affidavit that Judge Cholera reviewed yesterday and found that there was not proof evident presumption great. And having presented nothing further, this court has no more information before it than Judge Cholera did yesterday. So I would ask this court, in light of the fact that nothing has changed, to uphold Judge Cholera's ruling that proof evident presumption great does not exist in this case, and we would be asking this court to set bond.
Thank you, Mr. Reddy.
and Your Honor, if I may, I don't want to interrupt the court.
No, go ahead.
Your Honor, I just also want to know for the record, I'm renewing another objection. The state specifically requested of Judge Cholera why he did not find proof evident presumption great. Because without knowing why the court did not find it, the state could not possibly know how to perfect. Judge Cholera denied the state's request, found that it was not his responsibility, or he did not have a duty to advise the state why he was not finding that proof evident or presumption great was met. Your Honor, I made the request because it was the state's contention that a detailed statement from the victim of what occurred that was corroborated by the defendant's own sister who witnessed it.
All right, thank you,
certainly
Mr.
would
Linder.
satisfy.
Okay. There are three times a bond or release conditions, once set, can be changed. One's by the division judge. One is by the chief judge, who is me. And I would say, in looking at the probable cause affidavit and making specific findings, the brother of the sibling gave a statement to the police that he witnessed the molestation occurring here, described the victim, described the conduct, described what he was doing. I find proof evident and presumption great. I'm holding him no bond, and you guys can
And
hash
Your
it
Honor,
out with the division judge.
Just for record purposes, it was the sister of the
Yeah,
defendant.
the sister.
And Your Honor, in an abundance of caution, since he can still reach out and make phone calls from custody, I'd ask for an order of no victim
Well,
contact.
he's not supposed to have any victim contact. This victim in this case is alleged to be 10 years old. CL is the initials. Sir, you're not to have any contact whatsoever with this alleged victim in this case, and the rest of it will be resolved by the division judge. Good luck to you, sir. Have a good day.
And that is over defense objection, Your Honor.
Yes, sir, certainly. All right, thank you all. I think that's it. Thank you, Mr. Romero. Good to see you again. Thank you. All right, RPO.
Loping.
Thank you so much. Have a good one.
You bet. Oh, you know what? Oh, yeah, we do have capability. Let's see, off.